Hello everyone and welcome to today's Mondac webinar in association with Green and Spiegel, who will be addressing the uniqueness of the Canadian-US border and providing practical solutions to common cross-border issues. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Evan Green is one of the managing partners at Green and Spiegel and is certified as a specialist in immigration law by the Law Society of Ontario. Evan is called to the bar in both Canada and the United States and is able to practice federal immigration law in both countries. Evan has been practicing immigration law for over 30 years and has extensive experience in all areas of Canadian and US immigration. Evan has been identified for many years as a leading practitioner in immigration law. Jonathan Grode serves as the US Practice Director and one of the managing partners for Green and Spiegel. Jonathan has worked continuously in the US business immigration law field since 1999 and has amassed considerable experience obtaining non-immigrant and immigrant visas. In addition, Jonathan has significant experience dealing with Department of Labour and Department of Homeland Security enforcement actions, as well as immigration-related aspects of mergers and acquisitions. And before I hand over to Evan and Jonathan to begin today's webinar, a quick housekeeping item. You can submit questions to Evan and Jonathan by typing them into the questions pane of a toolbar on the right-hand side of your page. We will endeavour to answer as many of those questions as possible during our Q&A session. It's now my pleasure to hand you over to Evan and Jonathan to begin. Thank you.
Thank you, Dan. I think in the fact that we're limited in time and there's certainly things that are going on. The things I like to say these days is we're currently doing the webinar. It's 12:05 Eastern Standard Time. What we are saying now is accurate now. In an hour or two, may not be accurate. So I'm going to throw it to Jonathan to start with. Jonathan, what overreaching things have we noticed now that there's the change in the administration?
Thanks, Evan. I think it's important to recognize that what we're dealing with here with the Trump administration is not necessarily the same as what we saw with the first time around. And Evan, what I mean by that is certainly, immigration remains a focus, but the way that the administration is dealing with immigration, the exercise of the executive orders is different. And if you remember, like when we had the changeover in 2017, the heavy focus of the executive orders as they related to immigration were focused on this Muslim ban. And that's what got all the attention, the preclusion of people from certain countries being able to enter the United States. We don't have a Muslim ban this time. That wasn't the first order of business. Instead, the focus has been more clearly directed towards those within the United States that do not have status. And the executive orders that we're seeing have been heavily focused on the southern border, have been focused on enforcement activities, and those coming from other parts of the world have not had any specific indications of a change in policy or protocol yet. There's one exception, and that comes to embassy visa appointments and processing of visas that need to be put into your passport, which, as we will discuss in detail, Canadians for the most parts do not have to deal with. But there is this sort of extreme vetting. There are additional hoops that people have to jump through in order to clear security protocols in order to have a visa issued. And certainly the general tenor of administration and the way that things have been processed has changed. Certainly we're seeing more aggressive behavior at the border, at the consulates, but there's no specific law precluding anybody from entering the U.S. So, Evan, I think that that's really the biggest overarching change, but it is important to note, despite all the we'll say posturing that's going on with relation to Canadian and U.S. Political interactions and the specter of that having an effect on visas like the TN, we haven't actually seen anything come to fruition as of yet. But as you aptly pointed out, that is accurate as of 12:08 p.m. Eastern Time So it can change, and it can change rapidly. And we just have to be vigilant and be mindful of how these things are impacting individuals and businesses. Of course, I think that's the last thing that individuals and businesses want to hear, because we all crave predictability. But that is the reality of this phase of the Trump administration, where they're establishing their protocols and garnering what essentially amounts to a concentration of power under their mandate that they feel like they have to change the way the government operates.
So it's interesting in the Canadian context, I would say that changes started to occur sooner. And I would say that rumblings occurred sort of last year. And for the first time ever in Canada, we were getting negativity surrounding immigration per se. And, you know, I always said when I would speak, especially to US audiences, that in Canada, government policy was always pro immigration, pro. And, you know, we have three major political parties. They were all pro immigration. It was how they did things. Well, I'll tell you, our current government made such a mess of things that we started to see negativity in immigration, I would say, for the last 18 months. And it had to do with housing crisis and the healthcare crisis, and sort of being blamed on the immigration front. And we started to get sort of like check marks where the government went back and said, okay, we got to change this. And the first check mark we got was specifically students. And they said, hang on, we've let too many students into the country. And what I would say with students were sort of the impetus for all the problems, because what happened in Canada was the government said to schools, post-secondary schools, we're freezing your tuitions for local kids, but you can go get as many foreign students as you want. Foreign students pay 3 times the amount that local students do. So the government, the institutions went out and they recruited thousands and thousands of foreign students to come in. And the result was that these kids came in and they don't have an obvious path anymore to permanent residence that they used to have. And the students were actually sold a bill of goods where they said, pay for your education, and when you graduate, you'll get permanent residence. But there's so many that in our points-based system, which is the primary system, the numbers just kept going up and up and up and up. And what happened is, as a result, that those kids now who are graduating, a lot of them have been hired by businesses, and businesses have used the postgraduate work permit. And they get 1 year for 3 years of 1 year for each year of studies to a maximum of 3. Okay? And what's happened now is that those work permits are coming to an end. And unless the employer is willing to sponsor, because in Canada, you don't normally have to do that, but unless the employer wants to sponsor them, and this is the other part, pay prevailing wages, because under the postgraduate work permit, they can be paid anything, okay? So assuming they're making prevailing wages, they can sponsor them, but they have to prove that no Canadian's available for the job. So it's created a big kerfuffle in immigration in that part. So that was sort of like the first check mark. Then in the fall, we had changes to the intra-company transfer visa, where the government finally came out and talked about remote work and really tightened up on the remote work category. Since then, there have been more changes, and those changes have to do with the idea of flag polling. So flag polling, for those of you who don't know what the phrase means, is typically what happens is when you extend your stay in Canada, you apply online, there's a system, but it takes about 120 days for them to adjudicate. If you're a visa exempt national, a lot of times you can do those applications at the border. So you go to Buffalo, turn around, come back in, and do your application at the border. The government has stopped that, okay? They don't want that happening. I mean, there are some exceptions, but for the most part, you got to wait out your 120 days. So that's a big thing. And then the last thing that they did most recently is tightened up on spousal work permits. Typically, if you were in a skilled position and you had a work permit for 6 months or longer, your spouse could get an open work permit. Well, in Canada, spouse also includes common law spouse. Um, the government has now restricted it. You have to have a 16-month work permit in order to get a spousal work permit. And the categories under which you can get a spousal work permit have also been limited. So, like the US, there's a tightening. Um, the question I would say, I'm going to throw back to you is, do
Hmm.
you think things have changed at the border generally since the Trump administration was sworn in?
Yeah, I do. I mean, the officers have gotten a number of directives as it relates to certain programs and certain nationalities. Most notably, Evan, like you remember the whole kerfuffle with Colombia, and
Mm-hmm.
that occurred the first or the second weekend of the administration. I mean, that certainly had an impact. The border officers were instructed to take specific activities against Colombian nationals, and it was a concerted effort at all airports to query individuals further. I think a lot of that sentiment is bleeding through. I think you're getting a lot more um, sort of reluctance from the ports to exercise discretion. We've had numerous instances where, and I know this is not so relevant, but it's a to people in the business community, but it's a touchstone of what's going on, where ports in the past, if somebody didn't have the proper documentation or they weren't properly prepared, they'd be given an opportunity to be paroled into the U.S. And the parole is sort of a permission to enter. Well, now those decisions are all being reviewed by Customs and Border Protection in Washington, D.C. And officers and port directors, they're nervous about their jobs. Chiefs and supervisors are anxious about catching the ire of the administration. So that flexibility that would allow for individuals to make favorable discretionary decisions towards foreign nationals is dissipating. If it's a borderline case, we're seeing them err on the side of saying no instead of
I was going
saying
to say
yes.
no is
And,
an easier answer.
way easier. And we're also seeing, people being questioned more heavily when they're coming in and making applications directly at the border. And we see this, particularly for Canadians who are applying for TN visas and certain TN categories that have historically been challenging, like management consultant or economist or technical publication writer. These specific categories are becoming harder and harder to use. I mean, we've even seen instances, and this was started before Trump took office, but is becoming more prevalent, where the applicant for a particular position will be given a form to fill out and say, list all your job duties for your role in the United States. And if those job duties don't jive with what's being said in your application packet, those filings are being rejected or being denied. So, it's the way I look at it is, and to make a sports analogy, if this was a football game, it's not like there's new penalties that, and obviously I'm saying this because the Eagles just won the Super Bowl, but it's not like there's different penalties. It's not like there's a new violation, but the referees are calling holding more often. They're calling offsides. They're throwing those flags with greater regularity. So the way the game is being refereed or the way it's being adjudicated has changed, even though we don't necessarily have new laws specifically dictating that behavior.
So
And I
what's
don't
the
think you,
advice on how to deal with that? How do you deal with that?
well, I think it's a matter of being pragmatic. I think it's a matter of being prepared. I mean, with our clients coming into the United States, we've always done prep sessions, but we're putting a lot more effort and um, vigor and towards insisting most everybody go through a prep session. And Evan, we're not allowed to tell them what to say. That's not the objective.
That's
The
like when
objective is to,
clients ask me, oh, will you give us a script?
yeah,
Like I
we would
always say,
never ever in a million years
never,
do that.
never.
But, I mean, being familiar with the types of questions that are being asked understanding those questions and how to respond to them, um, and trying to ratchet down nerves is something that we're heavily focused in on. And Evan, for people that don't feel comfortable in that in-person setting, sometimes we're opting to do internal immigration filings. So let's just take example a TN where you would apply at the border. We might lob in an application with CIS, the Internal Immigration Service, and have it so that they're presenting an approval notice at the border rather than going there for a questioning to see if a benefit is going to be issued. So the strategy is changing a little bit.
Right.
We're trying to be a little bit more pragmatic. Um,
I
and
think,
really
but you
knowing your
yeah.
clients and understanding their personality is as much a part of it as rolling the dice and seeing what type of personality you're going to get at the border itself.
No, I think that the analogy that you made, the sports analogy, the key is the players need to know what the rules are. Okay.
Exactly.
So once they know what the rules are, people feel more comfortable. They know what the officer is actually looking for. Okay. When they're asking the questions, why are they asking those questions? I mean, one of my favorite things to say is work is a 4-letter word at the border. Nobody's coming in to work, right? They're coming in for business sessions. They're coming in for conferences. They have an answer to the questions. Nobody's coming in to work.
Correct.
Yeah. So it is certainly interesting times. Education is key. And, from the Canadian side, we haven't seen it yet, but I got to tell you, well, shouldn't say we haven't seen it. I mean, when we have 20,000 Canadians booing the American national anthem at a sporting event, I think that that's going to play out at the borders as well going forward. And, when tariffs are coming in, if they are coming in, I think that that's going to play out at the borders too. I mean, as you've said, the officers at the border, we don't know where they're coming from, right? And
Mm-hmm.
exercising discretion when you've got the official U.S. government position is tariff everything coming in from Canada. You can have somebody whose spouse was just laid off by Stelco, right? And not very happy about letting Americans into Canada. And it really is a whole new environment that we're heading into right now.
Yeah. And look, Evan, I do want to highlight that right now, the Trump administration and frankly to an extent the Canadian administration are
We don't
dealing with the
have one.
political.
We don't really have one right now. Our government's corrupt, so we don't really have a government right now.
A fair point. I'm gonna resist commentating on the French government, but I think we have the political sort of objectives that are trying to be fulfilled right now, and that's why it's particularly volatile at the moment. I do anticipate that we will settle into a new reality, and we'll understand the rules of engagement a little bit better once these directives are more firmly placed, once these border officers and consulate officers are properly trained. And from there, I think it will get a little bit more static. I think the objectives and agendas might be a little bit challenging for all of us to deal with. I think we are going to see far more stricter uh, government adjudications, just generally speaking. I do think that in 26 we are going to see a push for some sort of changes to NAFTA, and that could affect what do you call it, CUSMA, right?
CUSMA and
Uh,
Canada. CUSMA and Canada.
CUSMA, yeah, the USMCA. That can start being negotiated in 26. So I do think there's going to be more incremental change. But right now, we're sort of in this sort of shock and awe aspect of the administration, and it's a challenge. It's certainly a
Yeah.
challenge.
And I think with the Canadian government sort of in flux, and I don't see anything settling down here. I mean, we get a new prime minister at the beginning of March, so that's just a couple weeks away. We'll have a new prime minister, and then we probably are going into elections very soon after that. And until the dust settles on that, we're probably into April or May. Okay. And
Mm.
so that's what's happening up here. Uncertainty, which, as we know, not good.
Mm-hmm.
So let's sort of start with the slides, and we can sort of do an overview, and then we'll try to leave some time at the end for questions. So it's what we want to talk about is, do I need a visa? And that's sort of an interesting discussion these days, because I mean, Jonathan, talk about how long is it taking to get an appointment in Canada to get a visa if you need a visa?
Yeah, it's a bit of a challenge. I mean, right now, if you were to book in, you're looking at appointments a year plus out.
I like to say I can
Sometimes,
get you an appointment in February. Okay. I
yeah,
like to get I
February
can get you in
2020.
February. I'm just not sure which year February I'm going to be able to get it for.
Yeah, I mean, that's very real. And, I do, we do see for people that are residing in Canada, like Canadian nationals, that we can get quicker appointments. But historically speaking, a lot of people who work in the United States like to go to Canada to process their visas. That's not really a viable option at this particular moment. Um, so
And I
that's
think that
certainly a
that yeah,
challenge.
that basically what's happened is the reason for this is a two, I would say, primary. Number one was COVID, where they were closed forever, the consulates, and number two, what happened was the students that I was talking about, this huge number of students, that as well as the increase in the actual numbers of permanent residents in Canada. So we have this new population now with students and new permanent residents who want to visit the United States, and they haven't staffed up the consulates. The staffing hasn't changed in years. So you have a population that has exploded in Canada
Hmm.
requiring visas, and there just aren't the personnel to deal with it. And we're seeing, the way the system works is you book an appointment in 2026, and then if you need something earlier from a business perspective, you submit an expedite appointment, okay? And hopefully you'll get an expedite approved. We're seeing they're getting harder and harder and harder on those expedites. It
Hmm.
really is a trying time, okay, for that. But it's important to recognize that if you do need a visa, it's going to be difficult to get that visa from a business perspective. So we're talking about people in Canada who need visas to visit the United States, and also people in the United States who need visas to come to Canada. The timelines, although the ones coming to Canada are a lot better, they're still bad. And you're looking at probably 30 to 60 days to get a visa to come into Canada. The days of walking into the consulate and having a visa that afternoon just don't exist anymore.
And I think you also highlighted a really important point, and we've been talking around this, but one of the things that's been so challenging with U.S. immigration over the years for Canadians are those that are coming in for as visitors. Those that are coming in for business meetings, and as you said, work is a four-letter word, but there's a lot of gray areas here where Customs and Border Protection in particular has been very lenient. People that are coming in for work trips or snowbirding, and they're doing some work, and the government has always been, heavily focused in on what is the primary purpose of your stay. If you're coming as a tourist and you're answering some emails, that's fine. If you're an influencer and you're on vacation and you happen to take some Instagram photos and those get monetized, that's fine. But there's no written rule here, Evan. And I think, people have a tendency to say, well, this has worked in the past, so it's going to work again in the future. And I think you got to be a little bit careful there.
Well, let me give you a
You,
scenario. Give me your
yeah.
thoughts, okay? I'm 30 years old. I work in digital marketing, but I work remote, okay? And my
Hmm.
parents have a condo in Florida. And we're getting a big snowstorm today, okay? I don't want to be in Canada for the winter. So I go down to Florida in November. I went last year, November, and I came back at the end of April. So I spent about 5.5 months in the US. You think I'm going to have trouble this year going in if I spent that much time?
Potentially. I mean, that's
Yeah.
the reality of what we're seeing. We don't have digital nomad visas. We don't have a concept of remote work. We don't have any of these things that would be like seen as modern or progressive in terms of the way that we use the visitor visa classification. Your fact pattern is particularly interesting, Evan, because the source of remuneration is going to become critical.
Yeah.
If you're working for a U.S. company and you happen to be on U.S. payroll because you happen to have had a social security number in the past, um, you could be deemed working in the United States without proper work classification. Whereas that same fact pattern where the person is being 1099 or paid directly to their own personal number company in Canada, that could very well be okay because of the source of remuneration. And it's these little nuances that consular officers and border officers are globbing onto as justification for adverse actions.
Yeah.
So you really have to examine your entire relationship with the U.S. employer if you are in that remote work posture. And make no mistake about it, a lot of companies have been leveraging Canada in this regard because of that nearshore, same time zone ability that we have.
And if you haven't
And
noticed, our dollar's gone down quite a bit as well. So it's cheaper to hire somebody out of Canada these days for sure.
yeah, so I mean, it's 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 truly a fascinating scenario, but all of these things where Customs and Border Protection for the entire Biden administration has more or less given its blessing on, these sort of gray areas is where the referees are going to start throwing the flags.
I think the thing
Um,
to remember for a lot of people too is the information that they have at the border when you're going through. They have your entry and exits. They have all that information now. Okay. So the fact that you spent 6 months, or maybe you spent more, right? Let's say you spent 7 months in the US. That's a problem.
it can really be a problem. And, instead of allowing you to like withdraw your application, so, for those of you that aren't aware, like when you go to the border and you make an application for entry, if you don't quite do it right, or maybe you don't quite qualify for a TN classification, oftentimes, Evan, they let you withdraw your application for admission, right?
Hmm.
You know, now you might get a refusal, or if they feel that you've been lying or intentionally trying to misrepresent, not to scare people, but they can give you something called expedited removal, where essentially you're banned from entering the United States for a 5-year period. And we're seeing that occur with greater regularity.
Yeah. Yeah. I think it's interesting. Talk about the case that we had a couple weeks ago where the person had employment authorization and was trying to go back in.
Yeah, I mean, it's it's not easy. They're making the wrong decisions, and I know we've all had this feeling when you go to the border, you hope you get somebody nice, but there's so much discretion here, Evan. There's so much like flexibility for these officers to give their own opinion. It really does come down to what the individual thinks. Um, we've had people recently where they've had valid, and as you said, employment authorization documents, they've had the valid ability to travel, and they're not being admitted. We had one instance where somebody was granted TN the other day. They went and got on the plane, and the officer went back and pulled them off the plane to re-adjudicate the TN because the
Wow.
supervisor had a question.
Wow.
So, the extent, and I think we can't underscore this enough, but these border officers, these consular officers, they're people too, and they're worried about their jobs and their security. And that's affecting and dictating behavior.
Yep. Okay. All right. Let's move forward on the slides and see where we go. Canadian work permits. Okay. This is me. And the next one. So if you do need a Canadian work permit, as an American national, a lot of times we do use the CUSMA, the Canada U.S. Mexico Agreement, because it currently stands in place. And you can get up to 3 years at the border. Now, Having said that, depending on the category, sometimes we don't ask for 3 years. If you're coming in as a management consultant, we generally don't want to ask for 3 years, because then it becomes, how are you a management consultant if you're coming in for 3 years? It doesn't make a lot of sense.
Yeah, we do the exact same thing on the U.S. side. So it is worth repeating that these categories are interchangeable, right?
Right.
So
Right.
yeah, we take the same approach. Consulting is rarely for that long of a period of time, unless you happen to work for a company whose clients you're
Like if you're a
consulting to.
McKinsey, fine.
Yeah.
It's a professional management consulting position, okay? But if you yourself are a consultant and you're coming in to deal with an issue, 3 years is a little much to be asking for.
Yes.
We agree on that one. Okay, next slide, please. So this is really going over what the actual professions are. Now, it has changed with Mexico. That changed about 1.5 years ago. Mexicans used to be able to come into Canada without visas. They entered under the ETA provision, which is similar to the ESTA provision in the United States. However, if you're applying for a work permit to come into Canada as a Mexican national, you actually need a visa stamp in your passport. You cannot use the ESTA provisions. It's a unique thing. And for the most part, it works well, and it has continued to work well. But as we said, things are subject to change. Next slide, please. So the global skills strategy is very interesting in Canada. And what happened was, this is T1, are we calling it T1 now? Trump 1. In the first Trump administration, times were very different. And when Trump really tightened up on everything, the Canadian government recognized an opportunity and created what is called the Global Skills Strategy. And it was primarily created to deal with problems in the immigration stream. And one of the nice parts about it is it provides a short-term work permit for highly skilled people. Basically, you can enter without a work permit. You can enter twice a year for 15 days. There has to be a 6-month break in between, and it's 15 consecutive days, or once a year for up to 30 days. And it's not based on nationality. It's based on the job that you're doing. It's a highly skilled profession. You have to be at the O or A NOC category, so the highest level. And with that, you can come in for 30 days. So you're doing management consulting. You don't necessarily need a visa if you're coming in for 30 days or less, but you use it once and it's done. And it's basically from the 1 day to 30 days. It's not like, oh, I left for 10, you get 10 at the end. It's the clock starts and continues to run. Okay, next slide. Okay, so we went through this. We can flip next slide, please. Okay, intra-company transfers. So in general, intra-company transfers work very well into Canada. Bottom line is you've been employed for 1 year of the previous 3, transferring to the same company in a specialized knowledge or managerial role. One of the key pieces of the Canadian side is you must currently be employed by that organization. Jonathan will talk quickly later about the U.S. side and how that plays out. Now, if you're using CUSMA to come in, you can have a U.S. operation opening a Canadian operation, and that's acceptable. However, if you're from a country where we don't have a treaty and you're coming into Canada, in order to qualify as an intra-company transfer, it has to be a multinational company. And what the government came back to with that was that being a multinational company requires a presence in 2 countries. So if, let's say, you're an Indian firm and you just have offices in India, not in another country, you will not qualify for an intra-company transfer visa. You'd have to have India, Singapore, and then you could open in Canada. So that was quite a change in the rules that occurred. Next slide, please. Okay, we're going to flip the slide. One of the other categories we use quite a bit is the IEC. For anybody who's been to Whistler, it's all Australians. And basically it's for young people ages 18 to 35. And it's funny when I'm doing a lot of my consultations now for Americans who want to get out, this is what we use. And it's pretty much an open work permit, and it's all based on nationality and age. And you can get an open work permit. There's the working holiday, which is you don't need a job, young professionals, where you do need a job and it's sponsored, and then co-op. We don't do a lot of co-ops. It's basically part of your studies that you come in. 6 to 8 weeks of processing. It's specific to your nationality. So not all countries are covered under this. And the length of time you get is also based on your country of nationality. Next slide, please. Reciprocal employment. Canada has a unique category where if you can show similarly employed Canadians, you can bring somebody into Canada. It's a nice category that we use, somewhat limited, but it's still there. Next category, please. Significant benefit. Canada has this unique one where if you can show it's in Canada's interests to allow the individual to come in, you can apply for a work permit. And, you know, if it's an emergency situation, when you've got somebody who needs to come in, they're coming in for a particular problem or particular need, this is something that we use. But we use it sparingly, and it's a discretionary visa, meaning it falls on the officer to determine whether or not it really is in Canada's benefit to let the individual in. So we try not to use it very much unless it's sort of a last minute thing. Next, please. Oh, this is my favorite category these days. Canada has a federal program whereby if you are a French speaker and you have a job offer, you can get a work permit outside the province of Quebec. You can get a 2-year work permit, and it's quite open. And it's sort of our Hail Mary when we can't find a way to bring somebody in. The question becomes, do they speak French? And if they speak French, it gives us an opportunity to bring them in. Next, please. Okay, so the dependents have changed. In Canada, generally, dependents can get a work permit. However, the primary holder now has to have a 16-month work permit, and it has to be in specific categories or a high enough skill level in order to do so. So in the past, everybody's used to getting these. You need to speak to your immigration counsel because things have changed quite recently. Next, please. So the general rule for getting a work permit in Canada is the labor market impact assessment. And that's the one where you need to show that you've attempted to hire Canadians and there's no one available. And it's very specific in its recruiting. You have to recruit for 30 days, specifically on certain sites, give a recruiting report. You have to be paying prevailing wages. And with that, you get an LMIA. If you're from a visa exempt country, you can show up at the border still. If you're from a visa required country, you apply in advance and you can get your work permit that way. Next, please. Under the global skills strategy that I mentioned before, there's 2 very unique categories that you don't have to do an advertising campaign and you want to bring someone in. Category A is for sort of a key person that you're bringing in. It has specific requirements in the salary, and you need a referral from a government, not a government, but an agency. There's specific agencies that you go to who say that it's an innovative company and they need this individual in. And with that, you create, as you do within Category B. Category B lists out certain occupations, primarily IT occupations, where so long as you're paying prevailing wage, you can bring someone in. And so the carrot is you can bring somebody in. The stick is you sign agreements with the government as to specific rules. In Category A, it's employment metrics. In Category B, it's skills-based. You have to give skills training to local hires, and there's other things you have to agree to with the government that you will do during the course of the validity of the work permit. But the big advantage here is that you don't have to advertise the position. So it's really, that's very key for many, many employers. Next, please. Jonathan, over to you.
All right. Okay, yeah, next slide. I mean, we kind of talked about this. You know, the USMCA is the same thing as CUSMA. it's a parallel agreement. So the visa categories that are cited for U.S. people entering Canada are the same as Canadians entering the U.S. Mexicans do have different protocols that they have to go through, but they're privy to it as well because it is a tri-national free trade agreement. If we can go to the next slide, we have discussed about these particular problems with the B1 visitor. Canadians are visa exempt. They don't need ESTA. They can come into the United States. And unfortunately, because of some technical difficulties, I'm doing this presentation on my phone. So it's a little hard for me to read the font here. But essentially, if you're a business traveler, if you're looking to make an investment in the United States, if you're coming to receive a short-term course of training, these are all acceptable activities as a visitor. We talked about sort of these gray areas and the challenges that we're seeing and some of the problems that have arisen with the interpretation of what is a visitor and what is permissible. So this is a very critical area all of a sudden, because the last thing you want to do is essentially have a mission critical objective for your business, try to enter as the visitor and be told that you need a working visa, or worse yet, if we mentioned it before, if they feel that you've been giving misrepresentation, they issue a bar to your ability to come into the United States on a more long-term basis. So it's of critical importance to, really discuss with your counsel, with your company, whether or not you should be using this particular classification to enter the United States, even if it's worked a million times before, Evan. And I think that that's the thing that we really need to stress. The game has changed.
Yeah, what we're seeing more and more in terms of the game has changed is Canadian citizens who may come from a country of concern, and they're getting kicked back at the border saying, hey, there's something here, go to the consulate and get this cleared. We're seeing that more and more, okay? Because there's information dropped in the system every day, and they may have been to the US 20 times. Say a person's an Iranian national, but is a Canadian citizen, and now they're having trouble getting into the United States. Sometimes that can happen too.
Right on. Yeah, so I would really just stress it. This is a great place to put a flag or say, think about what you're doing when you're coming into the United States. And, in all honesty, if necessary, consider one of the working visa categories, which is what we're going to talk about next. Next slide, please. So here we're talking about the L visa, and there's some, really good high level points here in terms of who can use it for the duration and whether or not spouses can work. But the L1 is your intercompany transferee, and there's two flavors of it. It's L1A for managers and executives, and L1B for specialized knowledge. The thing I love about Canadians using the L visa, Evan, is that you can apply directly at the border. And that is such a huge advantage from a cost perspective, from a timing perspective.
Yeah.
But I also think, notwithstanding the discussion that we've had, generally speaking, the people at the border are a lighter touch on adjudication than those that are filed through the immigration and citizenship services. And I think that is just something to really be mindful of, especially, we talked about the people that are, anxious or, don't do well in the face of authority, but a lot of people are great advocates for themselves. And I always think if you're applying for an L visa and you have the opportunity to present your case to a person rather than on paper, it's usually to your advantage. It's usually to your advantage.
Maybe speak about renewals too and how renewals work. So in terms of renewals, you cannot do, Jonathan, you want to talk about renewals?
Yeah, I can you hear me okay? I think I just glitched a little bit.
Yeah.
So in terms of renewals, it's interesting. If you're using the L on an intermittent basis, which is defined as spending less than half of your time in the United States, you can do renewals and extensions via the border and they don't give you a hard time. But if you're regularly stationed in the United States, your renewals and extensions occur through citizenship and immigration. You don't have an option there.
Right, right. So you got to plan for that, for sure,
Mm-hmm.
for sure,
100%.
for sure. Okay, next slide. The
Okay,
E1.
so yeah, and the E1 is an awesome visa. This is another one that we really like. It's for trade. Now, Evan, I'm going to tell you, this visa used to be way more popular back in the day because it's really predicated on ongoing and systemic trade between the United States and Canada, where the United States is the majority trade partner. And, 10, 20, 30 years ago, it wasn't uncommon for there to be a very specific parallel import-export relationship between a company and the United States. With the advent of global distribution, the internet, and other distribution channels, the E1 has played out a little bit differently in its practicality of usage, but it's still a great opportunity. And the reason why I like this is because you don't actually need to have a U.S. enterprise. You don't need to make an investment in the U.S. to utilize the E1. If your company is primarily trading with the United States and they're employed by the Canadian entity, you can activate this visa. You do have to go to the consulate in Toronto to process this. There's very specific protocols. But at the end of the day, you pop out with a 5-year visa, which is like actually one of your best values per dollar of visa classification. And it's a really excellent tool for those that are primarily doing business in the United States. I think that this is one where those are using E1s, and we talked about tariffs and those kinds of activities, where the usage of this and the applicability of it might be further hampered if we start seeing Canadian businesses move production operations to the United States to eschew tariffs. We'll have to see how that all plays out, but it's certainly something that merits consideration. But if you go to the next slide, it's really nice to know that there's a counterpart to the E1 called E2, which is predicated on a substantial investment made in the US. And the E2 classification is very cool because practically any business where you've made this substantial investment can qualify. But if we talk about somebody that might be considering setting up operations or expanding operations to the US, this is an awesome category. The catch here, and this is for the E1 as well, if it's a Canadian-owned business, you can only support Canadian nationals using this classification. It's somewhat limited in that particular regard. So,
Yeah, the
I
thing, Jonathan and I were on a consult yesterday, and it was a great startup, right? And we're saying to the founder, we're like, great, you're Canadian. We're going to look at an E2, but understand that once you start diluting it, and if the majority shares are no longer Canadian owned, you don't qualify for the visa anymore.
Yeah, so it can be a little bit tricky in that particular use case. So, but overall, especially for individual entrepreneurs who want to maybe purchase a restaurant or get a small business going, a cafe, like this is the visa classification that we use most regularly. But we also use it for, very large corporate entities. Um, and when you're looking at a corporate entity, we look at where the primary location of the shares are being traded as the touchstone for analysis.
Next slide.
The J1 is a great visa. It's actually been expanded under the Biden administration. It's pretty much a training visa, Evan, and in the interest of time, we'll go to the next slide. But if you happen to have somebody in particular who wants to do an internship in the United States and they're attending a Canadian college, this is what we point to.
Criminal issues. So in Canada, the one we most see from our American friends are DUIs. Okay, and a DUI is an inadmissible offense for Canada. If you've had one within the last 10 years, you are inadmissible. Over 10 years, you're deemed rehabilitated. If there's more than one, you are inadmissible to Canada and you need special permission to enter. In the US, it's a little different. Jonathan.
Yeah, I think the first thing to note, and this is something I get all the time with people that have criminal records, they say, this happened so many years ago, how will they know?
I have a
I've entered the
pardon.
United
I
States,
have a pardon.
yeah, pardons unfortunately don't count. And just because you were admitted before doesn't mean you're going to be admitted again. And the reality is the reality is that Canada and the United States share records. If you've been arrested in Canada, oftentimes the US has information about this arrest. And it's best, again, to be forthright and forthcoming. And you might need to get a waiver depending on what's going on in criminality. But the last thing you want to do is get done for misrepresentation. Crimes involving moral turpitude, which is sort of like dishonesty crimes, controlled substances are a huge deal, multiple convictions. I mean, they're all highly problematic. Interestingly, we're a lighter touch on the DUI side of things than Canada. But again, it's one of these things where disclosing it and being honest about it is in the best interest. And depending on the crime, if it's a minor infraction, even if you've been arrested but you haven't gone through the court system, you can still be admissible to the United States. So it's the hiding of it that often causes people more problems. Most crimes you can get a non-immigrant waiver for. There's a whole waiver process. But Evan, I hate to tell you, just like consular appointments in Canada, the waivers are very, 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 very backed up right now.
Yep.
Very backed up. And we're talking about a year plus wait time.
Yep.
So,
and doing
plan accordingly.
We Jonathan and I used to have this sort of backdoor to faster waivers was through the consulate. If somebody had you can actually apply whether you're Canadian or national through the consulate, and that used to be a way to do things faster. It doesn't exist anymore. They're terrible, all around terrible. Next slide. We're running out of time. Questions? Okay, back at you.
Thank you very much, Evan. Thank you, Jonathan. And just before we move to the Q&A, I want to say thank you very much for your presentation today. Lots of very important information, incredibly interesting, and you've been able to give it to us in just under an hour. So we really appreciate your time. We've had a few questions in. We've got about 5 minutes now. So if you do have a question you want to ask, please send it in. I'll start with this question because we just covered E1 visas. We had a question from Holly. Do individuals qualify for a US SSN under an E1 visa?
Yes, you can get a social security number. You can, which is great. Anytime you come in with a working visa classification, you're allowed to apply for a social security number, E1, TN, L, all of that stuff. Visitors cannot, so that's something to be mindful of. But yeah, you can get a social security number under an E1.
I'm going to take it back the other way. The interesting part is we have a lot of people in Canada who are dual nationals, Canadian and American, who want to give up their U.S. citizenship. And
why would anybody want to do that, Evan?
Not these days. Why would they want to do that? So there's a huge, it's taxes, basically, but huge backlog in appointments to do that. And you hear people going to South America to do it because there's a better line there and they have to get things done in time. So, yeah.
Brilliant. Great. Thank you very much. We've got a slightly longer question. Evan, you may be able to see it in the chat. Jonathan, you might not be able to with your setup. But Catherine asks, you mentioned TN applications. What about current TN visa holders living and working in the US and traveling in and out of that country, either for work or vacation? Are they at risk of being refused re-entry into the US, one, right now, two, when the tariffs take effect, or are they protected by the USMCA for now? Does a border agent have the discretion to refuse an existing TN visa holder from re-entry?
I would say.
So yes, they do have the authority to do it, and we have seen it. It's those who are in those sort of categories where they question the applicability. Most prevalently, the management consultant category, Evan, gets a lot of scrutiny on people coming back in.
What happens if I marry an American and I file an adjustment while I'm on a TN?
Well, that's a little different. I mean, changing over to immigrant visa from a TN is highly problematic because of the intent quotient associated with the classification. But I do want to stress that the tariffs are completely independent of anything to do with whether or not a TN category is valid, usable, or applicable. So that won't impact it. But certainly coming back in and presenting yourself, anytime you essentially open your application for admission, there's a chance that you reject it. So yeah, sorry about that. Just to reiterate in case I got cut off there, anytime you make an application for admission, there's a potential that you could be rejected.
Excellent. I don't know, Evan, if you had any thoughts on that as well.
No, I think that, honestly, these days, anytime you enter the United States, there's risk, right? We can't say it's risk-free. It's like when clients say to us, I mean, one of my favorite questions, what's the guarantee here? Right? The guarantee is you're going to get excellent legal advice, but there is no guarantee. Okay? We don't have that availability. And anybody who does say they're going to guarantee anything for you, stay clear, because there's no guarantees here.
I think that's good advice. Thank you very much, Evan. So just looking at the time, and we've had a ton of questions in. I think we'll have time just for one more, but any question you sent in will be sent on to Evan and Jonathan, and we do encourage you to get in touch. You can see their contact information on your screen. So this question came from Dennis. Can a Canadian CPA enter the US to work for a US entity and still work under their Canadian professional corporation while living in Canada and traveling back and forth to work in both countries?
Jonathan?
Technically speaking, you're not allowed to engage in any activity that's not permitted by your visa classification. So if you have a visa to work for a specific employer and a specific classification, you can't engage in activities that are associated with any sort of personal business, regardless of the source of funds. Now, the risk of doing so might be incredibly low, but there is a risk. There is a risk.
I mean, that basically, they could say to you, how are you being paid, right? How's that working, right? And that could be the issue that you have.
Yeah. Well, certainly, Dennis, I think that you should get in touch with Evan and Jonathan, and you can discuss in more detail. And we encourage everybody here today to do that as well.
Yeah, and I just wanted to add one little note, given some of the technical difficulties and the fact that this is such a wide topic. If you did attend today's conference in person and you do write to us and you put the code word MONDAC in your subject line, you can get a free 15-minute consultation with somebody on staff to go over your specific questions. So that's our goodie bag present, your swag bag on the lawyer front for today.
That's brilliant, and I do encourage you to take advantage of that. So thank you very much again, Evan, Jonathan, for your time. It's been great to have you with us and to spend the last hour with you. As I say, an incredibly important subject right now, and you're able to impart a lot of very valuable insights and information for us. So thank you again. Thank you also to our audience for being with us. We really
and most importantly, happy Valentine's Day to everyone.
Of course, of course. Please don't forget. Please don't forget tomorrow.
Happy Valentine's Day. Bye, everybody.
Brilliant. Thanks, everybody.